Hello, everyone. I'm David Carnahan, the City Clerk for the City of Sunnyvale, and I'm here to introduce us to research and navigating the City Attorney-City Clerk relationship. City clerks and city attorneys are key legal professionals in local government. This session will focus on tips navigating the City Attorney-City Clerk relationship, as well as conducting legal research on areas of mutual interest, including the Brown Act, elections, conflict of interest, agenda preparation, ordinance and resolution drafting, as well as meeting management. The session is scheduled to last until 3 p.m. and due to the 2-hour nature of it, we're going to go with no break in there. And I'd like to remind everyone that this conference is made possible in large part by our sponsors. And we'd now like to display 2 brief videos that'll tell you a little bit about our presidential sponsors, NetFile and Granicus. Can we please play the videos? And I have great hopes that someone has the videos since I don't have them. All right, well, if we get interrupted as I'm talking with some videos, we will appreciate learning more about NetFile and Granicus, although I'm sure you're all very familiar with both of those vendors. A reminder that CCAC will periodically review the participant list to ensure attendance for the full duration of the session. And a reminder that the session materials and the learning assessment for each session can be found on the conference website, www.clerksrock.com under the course description. And then the certificates of attendance will be provided after the conference. But if you have an urgent need to get a certificate right away, please contact CCAC President Anthony Mejia. He can make arrangements for a faster delivery. And now I'd like to introduce our speaker, Glen Googins. He was first elected in June 2010. He's currently serving his final term as Chula Vista's first ever elected city attorney. As the city attorney, Mr. Googins is committed to providing the city with high quality, unbiased legal advice, supporting the efficient delivery of city services, fairly interpreting and applying city laws, protecting taxpayer resources, improving the flow of information between the city and its citizens, and ensuring the city itself complies with, as we all know, a myriad of laws that sometimes contradict each other. Mr. Googins received his undergraduate degree from Dartmouth College and his law degree from Berkeley Law School. He's a member of the California, San Diego County, and South Bay Bar Associations. He's also served as the president of the City Attorneys Association of San Diego County. Mr. Googins resides in the Chula Vista community of Eastlake with his wife, Maria Elena, and they are on the cusp of empty nesting with the last of their 4 children now off to college. So thank you, Glenn. We appreciate having you here to lead this wonderful session.
Very good, David. Delighted to be here and given the opportunity to present to this group. Hopefully some of the information I will be providing you will be on topics of interest to you. I think I pretty much cover most of the things you outlined that I was going to cover with a couple of minor kind of last minute edits here. But if you give me just one moment, I'm going to call on my IT director, who's immediately to my left here, to get me kind of queued up to make sure the presentation is all situated.
Glenn, if you don't mind, this is David with CCAC. I'm just going to share the commercials as they wouldn't play earlier. Is that okay with you?
Of course, of course.
All right, here we go.
File number 1 for city clerks. Over 90% of all cities that use an electronic filing system use NetFile. That's over 120 cities. Only NetFile offers third-party campaign finance software used by over 70% of Secretary of State filers. And NetFile offers one-of-a-kind features like RSS feeds, independent expenditure searches, and free one-on-one NetFile campaign filer application training. Why is NetFile number 1 for Form 700 filings? Over 72% of FPPC-approved e-filing cities choose NetFile. And our software comes with all features, no upsells. Unlike the competition, we provide unlimited training and support at no additional cost ever. And only NetFile offers advanced public search features, mobile apps through the Apple Store and Google Play, and advanced validation, virtually eliminating amendments. Last but not least, service and support are our specialties. Visit us on the web at www.netfile.com or contact Tom Diebert at sales@netfile.com.
As a public servant, you work hard to deliver vital services to citizens while complying with regulations. That's not easy. You're plagued by outdated systems and drowning in paper-based processes. As your organization's workload grows, it's hard to keep up. Imagine a world where you become the hero of the meeting process. With Granicus, you can do just that. We make it easier to prepare, run, and follow up on civic meetings. Granicus enables you to balance last-minute agenda changes, giving you the power to keep your citizens informed. We have one goal: to turn you into the hero. We streamline your tasks while saving you time to focus. Our platform is purpose-built for governments and trusted by over 4,000 organizations across the globe, so you get easy-to-use tools that meet your needs. We ensure you never have to print an agenda again. No more wasted paper. No more battling the printer. We make it easy to get them approved. We help you automatically create minutes, share them, and drive your citizens to action, all while getting the job done quickly and easily. When you partner with Granicus, everything's possible. Reach out to us today, and we'll show you how Granicus can make you the hero of your department.
Oh, whoops. Sorry, my fault. Come up. Okay.
Very good. Can everybody hear me?
Yes, we can hear you.
Oh, son of a biscuit.
And can you see my screen?
Yes.
Very nice. And does it say navigating the city attorney city clerk relationship with research and practice tips?
Yes, it does.
Very good. Well, we're off to a good start. Very good. Thanks, Ed. Thanks again for having me here. Really appreciate opportunity to speak to this group. And I'm interested in those commercials. I'd never seen that before in a setting like this. And that was kind of cool and interesting. Before I dive in advance, I really want to thank some of the folks that helped me put this together. As you guys know, anyone who's done presentations like this, particularly over a couple of hours, it's a major enterprise, and you don't ever do it by yourself. And that certainly wasn't true with me in this case. I had a lot of help from very good lawyers in my group, including Jill Mayland, who advises the city clerk on elections issues, and a variety of others. Mike Shirey, who's the lead attorney on Public Records Act issues. Simone Silva really advises on everything, but a lot of advice on conflicts of interest and the Brown Act. Megan McClure is one of my crack litigation folks who does a lot of legal research and who provided me some tips on that as well. But special thanks really want to give to Melanie Caluco, my law office manager here, who did yeoman's duties in assembling all the information and having the PowerPoint come together, and some of the supplemental materials, which may or may not be posted yet, but we'll make sure they're posted for everybody's access. If not during the presentation, then shortly after. So special thanks to all of those people. I would be remiss if I didn't also afford special thanks to what I describe as my city clerk muses. I've been at this a long time. And in the early 90s, when I first came to the city, Beverly Aucklet was our city clerk, and she was just a super nice and professional person. And it kind of began my appreciation for what the city clerk does and how important they are to open, transparent operation of government. She was followed by some pretty extraordinary ladies in their own right, Susan Bigelow, Donna Norris, and of course, Carrie Bigelow, who is now my hero city clerk, and also contributed a lot to this presentation. And I know you heard from her earlier today, and I'm sure she was excellent. It really is given me an appreciation for your profession, the special relationship that we have, and a lot of what you hear today from me, if it's any good, will be a product of some good training I've had from my city clerk muses identified here. Quickly, a little bit about me. You heard more about me than I thought you were going to, but I did attend Berkeley Law School, graduated in 1988. I've been at this a long time. 23 of those 33 years I've been practicing. I've been a city attorney at various levels with the city of Chula Vista. I did become Chula Vista's first elected city attorney back in 2010. It was a very interesting and wonderful, really, experience. Mostly because I just couldn't love my job more. To live in your community, a community like Chula Vista, especially growing the way it is on the cutting edge of so many things with excellent leadership in the departments, and right now, pretty darn good mayor and council too. Especially well served in our city clerk's office. To do that for the community that you live in, and with all the different interesting and complex legal issues and projects we deal with, it's just fantastic. So I feel very lucky to have this job. The stuff I'm going to talk to you about today is identified here. The special relationship that we've got, I want to probe that a little bit and talk about some of the nuances of that. I want to share with you some tips and ideas for finding the law when that's necessary and appropriate. Some tips and procedures for following the law of areas of mutual interest. And then if we have time, questions and hopefully answers, from me. I know Carrie's going to be monitoring the chat. If a question comes up during the presentation that she feels appropriate to interject on, she has my approval to do that. And I'm happy to pick up questions as we go along. Okay, special relationship and the roles of the city attorney and the city clerk. I did want to take just a moment here really to celebrate and talk about that special relationship that we have, because let's face it, we're kindred spirits. We're kind of nerdy about stuff, but we'd like to think the cool kind of nerdy because we're the rules followers of the organization. And open, transparent, ethical operations of city government is not just a credo or an expression for us. It really is our professional responsibility. And I know something that all of us take great pride in. That does not always make us popular, however. And in fact, there's frequently a dramatic difference between how we see ourselves and how others perceive us. And I think that's especially true with city attorneys. We see ourselves, of course, as heroic defenders of justice, as depicted here in Rembrandt's Night Watch, which I saw recently in person at the Rijksmuseum in Amsterdam. I highly recommend it. It was being restored at the time. Everyone needs to go and see this painting. But this is how we see ourselves. We're these heroic figures protecting all that is good and honorable about open and transparent government. Unfortunately, others often see us as the dreaded nightmare of their professional experiences. Now, that's much more true of the city attorney than the city clerk. You are the nice ones in this equation. A lot of city attorney offices could learn a lot from that. And the city clerks, I think, greater success with having a service-oriented approach. But it is helpful to have us around as maybe the darker side of rules following. We're often called upon to give bad news to people about what they can do, what they can't do. And you should use us that way, like everybody else does, as long as you're nice about it and don't put us in too awkward of a position. God knows everybody else does. And so the city clerk should do that as well. We have, as you all know, very, very complementary roles, but they're different. I think that brings us to kind of an important distinction I wanted to harp on a little bit here in the beginning of the difference between the roles of the city attorney and the city clerk. Because for as much as we have in common, it's really important to understand the different roles and for each of us to kind of stay within our boundaries. This in our advisory capacity is a very brief, doesn't do it justice, summary of what we do. We're essentially the legal advisor, and we provide advice to all city officials on when and how the law applies to them in their official capacity when they're acting on behalf of the city. The city clerk, very similarly, is interested in the law, but more in the capacity as an administrative and a compliance officer. It's very important for you to know the law, follow it yourself in your administration of your duties, and in the areas you administer, provide others the resources and information necessary for them to follow the law. While we're both legal professionals and very aligned in our purpose, it's really important to know when to ask for help and to know the difference between following the law, helping other people be aware of the law, and providing legal advice. City clerks should avoid the practice of law. And this slide attempts to kind of illustrate, where that line is drawn. And I'm going to give examples of that really throughout the presentation. It's obviously okay for you to provide information or direct people to known legal resources, but it's not okay and risky for you to advise on how the law applies to a particular set of facts. For example, if someone's asking you about, how they should describe themselves in their ballot language or what their designated profession would be. Those are things they need to sort out, and you can point them in the right direction, but you shouldn't be deciding that for them. The consequences of overstepping this boundary are potentially significant. It could create city liability or a lawsuit, depending upon the circumstance, and certainly could have an adverse impact on the clerk's standing in the community or their standing in the organization if they're going beyond kind of some of these limits. So some practice tips in a couple different situations in general, and then a couple of different situations is going to be very much part of this presentation, and hopefully help you be wary of this line and avoid crossing it. It's absolutely appropriate and necessary for you to direct people to known, reliable, whenever possible, obviously, legal resources. When you are directing or providing information to people, it's also a good idea for you to provide disclaimers that you're not providing them legal advice. In emails, in written materials that you distribute, even in conversations. And if it's in a conversation, it's not a bad idea to make contemporaneous notes about what you said to people and what you didn't say. And it's also very important for you to, where the situation is appropriate, refer people to legal counsel. If you're advising and talking with city officials or employees involving city business, of course, you refer them over to the city attorney or the city attorney's office. Everyone else, you would direct to private legal counsel. It's not a good idea to refer people to particular lawyers. We shouldn't be vouching for or steering business to any outside lawyers, even if we know good ones. But it is a good idea to have handy the local lawyer's referral and pro bono attorney services in order to be able to help people out if they need to seek legal counsel. In managing this line and awareness of the line in running your own office or overseeing compliance within the city, some other practice tips. Never hesitate to ask for advice, even if it's just to confirm your understanding. Don't necessarily get too comfortable if you've gotten previous advice in an area. That previous advice might not apply. And general information you get from a seminar like this or from secondary materials also might not apply to your situation. And as much as we all try to keep up with the law, the laws and their interpretations are constantly changing. And so getting too comfortable in what you know and what you don't know is not a best practice. In complicated or high stakes situations, ask for an opinion in writing if you need that level of clarity. Could range from a confirming email to a formal legal memorandum, depending upon what the circumstances require. But when you're asking for things in writing, we would ask on the city attorney's side to be sensitive to workloads and the timing constraints when asking for a formal written legal opinion. A lot usually goes into those. But if that's what you need and the circumstances call for it, don't hesitate to ask for it. And I want to be clear about one thing. I keep saying ask for advice, and I'll be saying that kind of throughout the presentation, and it may end up annoying you, but believe me, I know that an experienced city clerk frequently knows the law in city clerk areas as well or better than their city attorney counterparts. And I think that's true of many departments. Public work folks frequently know the public contracting code or the city's own procurement rules better than the city attorney, particularly in a small shop where your city attorney is a generalist and knows a little about a lot of things, but not necessarily a lot about everything. And because of this, because you are legal professionals, if not lawyers, you should not be shy about speaking up. Don't hesitate to learn the law, to spot legal issues and bring them the attention to to everyone involved. It's absolutely part of your role. And as I said, a lot of you know the law better than your city attorney counterparts. So obviously try to do it in a nice way, in a way that's cooperative and constructive and doesn't show anybody up, but your city attorney is not infallible. So how to raise legal issues is something you can think about. When you do have an issue and you're asking for advice or troubleshooting and spotting an issue, definitely include your city attorney in any written communication regarding a legal issue or concern. This is really important to establish and maintain attorney-client privilege on legal advice or issues or risks or exposures that you might be bringing to folks' attention. So directing communications to the city attorney, or at least CCing the city attorney, and marking things attorney-client privileged is a good idea. If you are seeking legal advice, it's also really helpful, particularly if you know an area, to do a little advanced research to identify the laws that you believe are apply, or other policies, especially that you're familiar with in the city that would apply. If you warm up the legal analysis for your city attorney, they will be super, super grateful. I promise you. If you are communicating with outside parties, please make sure you're not forwarding information or advice that is privileged. This frequently happens more than I'd like to think, with email strings being forwarded that seem innocuous at the tail, at the part that you're sending, but has a series of exchanges and communications that may themselves be privileged, that may identify uncertainty about an issue, past misconduct that would need to be addressed, and none of that should be cavalierly disclosed to the public. So please be wary. It will happen from time to time that you disagree with your city attorney office's advice. And there's kind of which I think more than anything emphasizes the importance of having a good professional working relationship with your city attorney, because these kinds of things can be sorted out. And there's often legitimate varying opinions, as you all know, about different areas of law when law conflicts, or different groups interpret things one way and others the other. But in terms of protocol and how to engage this, it can be a sensitive matter with your city attorney, no matter how good your relationship is. So if you do disagree, discreetly, ideally, bring the disagreement to the advising attorney's attention. Be prepared, and it's okay to go up the chain of command to the city attorney themselves if necessary. It's okay if you really feel strongly about something and it's in a high stakes area for you to request a second opinion. If that still is not working, it is also reasonable and appropriate for you to bring the matter to the direct attention of the city manager or the city council as appropriate, depending upon the nature of the issue. As a very last resort, you could seek outside advice, but it really is a very much of a last resort where there's an obvious mistake or issue being created by your city attorney. Your city attorney is ultimately responsible for providing legal advice. And if the advice is not coming directly from them, they should be the ones who choose or solicit outside legal advice. It doesn't help, and it often hurts to actually have multiple legal opinions unless that's coordinated. And you really don't want to compromise your relationship with your city attorney in that arena. So hopefully that would never happen, but those are my thoughts about how to approach it if it does. The ultimate goal, of course, for everybody is legal compliance. And the two of us obviously should work together as a team to sort that out. Which of course leads me to maybe my favorite cliche, overused, and I'm overusing it here. We are all in this together. It really is true. And it couldn't be more true about the city attorney and the city clerk. Law is complicated. City business is complicated and moves fast. And building the relationship with your legal advisor, where either of you can give the other a heads up as legal issues arise, is really, really important. Very important to the city's operational effectiveness, to ethical approaches to problem solving, and really just building positive, trusting relationships between all staff and staff in the elected, and ultimately the city generally with its community. So that is a very important relationship that we should all cherish and nurture. I wanted to take a little bit to give you an example of how my office interacted with Carrie's office here, not because there is any real magic to it, but I really do think it highlights difference of the roles and how folks can really do a good job to get along, with each other and assist in ultimately coming up with a solution. I asked Carrie not that long ago to work with one of my attorneys, Jill Malin, to come up with an approach to implement waiving the reading of resolutions and ordinance text in a systematic way, other than having every motion and action rely on doing that. It seems kind of silly, but it's in our charter and a lot of your charters and in general law cities too. But aside from the fact that we ought to follow the rules as a matter of principle, you don't want legal challenges to important city actions. And so I sent Carrie an example of how I'd seen another jurisdiction handling this and asked her to work with Jill to sort it out. Carrie, of course, took it upon herself to research the city charter and the government code, sent back to Jill in our little LARC attorney advice program that we've got that works really well. Those identified applicable provisions and even identified some potential legal issues in interpreting the term after reading of the title in a variety of different contexts. She also went so far as to survey other California cities. Some of you may have gotten her inquiry about this on your listserv to see how other people handled this and provided us information of the 42 cities that replied. Thank you very much for anyone who replies on listservs. It's super helpful. 21 did it one way, 16 did it another. There's a couple outliers who did it different other perfectly appropriate ways. But then Carrie also gave her recommendation in light of all of that of how she thought it all might work. My lawyer, Joe Mellon, was super appreciative and responded back, obviously thanking Carrie for all the advance work that she'd done in helping warm up the issue, and then said, with her advice, since our charter spells out a specific procedure for adopting ordinances, it would control over state statute. She gave a case that she cited. You point out the charter language is subject to interpretation. The city's interpretation of its own charter is entitled to great weight and will be upheld unless clearly erroneous, with another case cite. The city's past practice indicates that the city has interpreted the charter provision as allowing the motion to waive prior to the actual reading of the title. This interpretation would be afforded deference by the court if challenged. Thus, I don't see a need to start requiring that the action to waive take place after reading of the heading. With respect to the preferred options that you laid out, I would learn towards A, and she went over the other ones that didn't really apply and conformed that with the way our charter works, which would be to add at the beginning of a consent agenda, a standard item that they approve as part of the consent agenda, waiving the text if the heading is read. This kind of interaction between the two of them really shows a really good relationship. Preliminary research conducted by the city clerk, who's smart enough and capable enough to do that with applicable rules identified. A survey even conducted about how other folks do it with a thoughtful recommendation about how it might be approached. The assigned attorney reviewing the cases, not just the statutes, but applicable cases, taking a deeper dive into the case law and statutory interpretations, and then making her best recommendation based on city practices and the unique provisions in our code. That's how it's supposed to work on a small thing, right? But small things are important. And if not handled correctly, they could lead to bigger things. So I just wanted to kind of share that with everybody about two good professionals acting, within their lanes and ending up with a good result. Okay, enough about our special relationship. I want to talk to you now about finding the law, because that is appropriate for you to do as we've discussed. And there really is a lot of value to city clerks being legal professionals and being able to research things. It's just important for you professionally, I think, to be comfortable finding and developing an understanding of the law. It not only serves the city's interests, it does serve the interests of your profession and your own professional career interests. It's also important because sometimes your city attorney won't be available in a timely way, or if you've got a contract attorney, in an affordable way. And as I pointed out a couple times now, your attorney will very much appreciate your advanced efforts to identify what you believe are the applicable laws and a summary of the facts that will facilitate a expeditious analysis and advice from your city attorney. So where to look for the law when you're trying to track it down? There's kind of three areas to focus on here. And where you look will depend on the circumstances. If it's just a minor issue and you're looking for a confirmation of something versus a major issue that could result in litigation, and you're wanting to give your advising attorney a heads up, you may look in different places for your legal information. But there's generally three categories. The first is so-called secondary sources, general summaries and analyses of the law, frequently with citations to the law. Primary sources, which is the law itself, statutes, regulations, cases, administrative rulings. And then finally, not to be overlooked, your peers. And although it's titled secondary sources, I want to start with secondary sources because that's actually frequently, given the nature of what you're all looking into, a good place for you to go, start, and maybe even end. I want to start everybody with my favorite secondary resource of all, the California Municipal Law Handbook. The Municipal Law Handbook is a very comprehensive summary of laws, including federal ones that apply to the operation of local agencies in California, state laws, equitable principles, all governing the parameters in which cities can lawfully operate. It's written by the League's City Attorney's Department, which is a lot of very experienced lawyers broken out into different categories, focusing on different parts of the book. It's been published since 1993, originally by the League, now by CEB. It's updated annually, and various sections get more comprehensive overhauls from time to time, depending upon how much change has been made and how dated they've become. I laugh a little bit here because I'm showing you the picture of the 2019 version. There's actually a 2020 version that another lawyer in my office gets dibs on. And I'm even as the city attorney stuck with the 2019 version of it, but it's all pretty darn good and pretty comprehensive. Here's a summary of what's included that is of particular interest to city clerks. The Open Government and Ethics section, it's about 135 pages of summaries, includes open meeting laws, ethical considerations and conflicts of interest, and really good pages on the Public Records Act. It's also about 90 pages on elections, procedures, candidate qualifications, ballots, initiatives and referenda, election contests, recall, campaign contributions. It's really, really good. Now, obviously, all of it doesn't pertain, to you. It's a pretty massive tome. But if your city attorney doesn't have it and you can't get access to it, I would consider getting it. It includes practice tips as well. It's not cheap, but I think it's worth it. It's about 400. I think it's $435 currently, and it's available both in digital format and in print. So. Touting the California Municipal Law Handbook. As you all know, because I bet you access these things, there are really other useful publications as well that I would put into the reliable resource category. These are here that you're probably familiar with, are really well done and useful. A lot of it's written in layman's terms and meant to be shared with the public. A lot of them include practice tips. Open in Public is excellent on Brown Act and Public Records Act. The Attorney General Brown Act handbook isn't updated as much as I would like, but is a good treatise. And then the People's Business Guide to the PRA is really good as well. The last one here is an ethics law book that I believe is published by the ILG. All these are really, really good. And I would highly commend them to you with links. I know you've got some special city clerk resources that I think are super useful and good as well. I know there's a city clerk's handbook. I spun through that. Boy, it's really comprehensive and with lots of forms and practice tips. I can see how that would be useful. The only thing that had me a little bit concerned about it is it appeared that it was last updated in 2012. Boy, a lot's happened since then. And I would highly encourage whatever group of you would be active and interested in doing that and digging in on that and creating an updated version of it. I can't begin to tell you how useful our municipal law handbook is and how much confidence I have in it with the attention I know that's given to updating it. Carrie pointed out to me there's a really good elections handbook, Martin and Chapman, that is kept up to date with really good forms. So on her recommendation, I would highly recommend that as well. And of course, your listservs are super, super valuable, almost invaluable. And I would commend you to pose questions and don't be bashful about posing questions there. Respect for listservs, I think is important. I know on our version of that, it's called Forum. Sometimes people are just use it in a lazy way. Hey, what's the law on this? Where you should be able to look it up yourself. It really should be reserved for things you haven't seen before or where you're looking to poll people on how they're approaching different things. Just to have it a cheap way for someone to answer a legal question for you strikes me as not the right way to use a forum like that. All right, I may get in trouble for saying this, but you could always Google it. We do here in my office. I don't underestimate the value of Google. Plus, although I'm still waiting for the royalties on this, I'm thinking because of the similarity to my name, I ought to be getting royalties for every Google search that's done. I'll keep looking for that. So the more you use Google, the better as far as I'm concerned. You know you want to use it. You have my permission to use it. Obviously, don't make it the last word on any research that you're doing unless you can confirm the reliability and understand the limits of the source. But it really is a great place to start and super useful. And I don't want to discourage you from using that as a way of entering into a subject that you're interested in. Oftentimes you'll come across law firms' summaries and analyses of new cases. Again, need to be taken with a grain of salt if you don't know the firm, but a great way to kind of educate yourself generally and round out your knowledge of areas, both old and new. Okay, the law itself, primary sources. In a lot of our circumstances, really the first question we should be asking ourselves is there a state statute or local law that governs this situation? And of course, as we all know, living in California, there usually is. And if there's not a law about it already, there's about to be. Someone's thinking there should be a law. We've got maybe more than our fair share. There are particular laws, of course, that are of particular interest to city clerks and city attorneys regarding operation of government. And those are found in the government code. Boy, all sorts of areas covered by the government code, the elections code, and with respect to interpretations and implementation of the Political Reform Act, which is in the government code, the FPPC regulations, which are very detailed. Aside from state laws, again, as you all know, local laws are just as important and sometimes more important because they can prevail. If you're a charter city, you've got to look at your charter. There's a lot of operational, particularly in the older charters with older cities that were very, very detailed about city operations. There's a lot in there, and there's traps for the unwary that we need to be aware of. That if not, because if procedures aren't followed, it could put the decisions made that were made following those, not following those procedures at risk. So being familiar with your charter and having that as a ready resource is very, very important. Obviously, the municipal code, equally important. And then administrative policies and procedures, another area where I know in the city of Chula Vista, we have a lot of these. And because it's not something that the city clerk has always been given access to and control over, because it would be completely squared away if she was, these things kind of get lost. The city council policies are easy enough for the city clerk to keep command of, and that's a really important resource. But being aware of and bundling and having be searchable, all the different administrative policies and procedures that they are, very, very important to both to look at and ideally for the city clerk to have responsibility for managing. A practice tip here, where state and local laws conflict, consult with your city attorney. That's not an area where you should be trying to figure out yourself. Laws regarding preemption and municipal affairs are complex. The legal conclusions that courts reach about them are not always logical, and these types of issues are frequently litigated. So if you're in a charter city, or even if you're not, and you've got local, rules that are not necessarily in alignment with the general laws in state codes, that's an area where you're going to want to talk to your attorney. Okay, the best way to find the state statutes that we're talking about here, I've listed here. Obviously, the primary one is the official source in the state of California website. It has both existing laws and frequently good coverage of pending legislation. I don't know how, I'm forgetting how searchable it is, but I think there may be some searchable ability there as well. The league website also has a law section that gives you pretty good access to areas of the law affecting cities. The FPPC similarly has portals and access both to underlying state statutes and implementing regulations. If your city attorney has Westlaw, that obviously costs money, but you don't need to be a lawyer to use it. So if you have a license to get on Westlaw, That is another very helpful way of finding laws. They've got a really good statute search template. Sometimes when you search for statutes on these other sources, it doesn't go right to what you need, and it might give you a much broader search range or something other than what you searched. The templates in Westlaw are really good for zeroing in on what you want, and has the added benefit of annotations. It shows you the cases that actually interpret those statutes. So Westlaw is pretty great that way. Google it again, still okay, but be careful within the parameters I previously described. And FindLaw is actually a pretty good source. Not as the last source and most reliable, but a pretty good source for searching. Case law. Case law in California and throughout the country is useful and often necessary to interpret statutes, decide whether or not conduct is lawful. Statutes frequently are drafted badly or not drafted to cover every conceivable situation. And so case law is necessary. Case law also establishes principles of common law, rules of conduct or responsibility beyond codified law based on all sorts of old English rules and rules from different theories of law throughout history. So it's not only just statutes that would govern, cases themselves can independently govern. And references to cases can be found in many of these secondary sources I cited and on Westlaw, as I indicated, especially useful in code annotations or Google searches. But I have to tell you, again, thinking about keeping in your lanes, while it's good to read and understand key cases in core areas, the interpretation and an application of case law rulings to your fact situation is the essence of practicing law. So it's not something that you should be doing yourself in advising or in determining legal compliance. By all means, don't hesitate to share cases that you find and even your thoughts on them with your legal advisor, but best practice is to leave case law interpretation and advice to your lawyers. That's what we're here for. Your peers, another source of finding the law and answers to really everything. And I bet this group agrees. We've got really great professional associations, both locally here in San Diego County amongst the lawyer groups, statewide, regionally. There's really no better source of information than your city clerk colleagues, both experienced and new. They offer different things. So don't hesitate to reach out, to make yourself available to others as well. Really very important source of information. And good for fellowship and good of the order in tough times, even if it's just to commiserate, as you all know. Okay, I'm doing a time check here. I'm not doing too bad, a few minutes behind, but I'll try to speed things up here a little bit. Following the law, primers and practice tips and key practice areas. The idea of this next segment is to provide you really a basic primer reminder of laws in various areas of the city clerk responsibility. Hopefully I've struck the right balance with that, because I know, again, a lot of you know this stuff pretty well. I enjoy going to seminars sometimes just to hear about areas where I'm pretty familiar with it, but just to confirm my knowledge and make you feel good that, oh, I do know stuff. And obviously with things changing, you've got to gut check that all the time because there are nuances and different interpretations of things. But more than anything, I really wanted to include practice tips within these different areas of the law on how to issue spot, to address legal compliance issues and work with your city attorney's office as we both look to understand the law and apply it to our particular circumstances. So twofold purpose in this next following the law segment. First area of law that I want to talk to you all about is Political Reform Act. This is one of those areas where there could be many hours of presentation on this topic alone. It would be brutal and tedious in many respects because of how complicated the laws are. So I'm not going to torture you too much with that. But obviously an important area where we are in some respects compliance officers. And so I'm going to focus on the compliance officer area of conflicts of interest in financial reporting in this, and hopefully that will be helpful to you. As we all know, the Political Reform Act is found in the Government Code. Section where it starts is right here. It's enforced by the Fair Political Practices Commission and the Attorney General's Office, the FPPC. It's implemented through FPPC regulations and opinion letters and advice letters. The regulations are found at this site here. And it generally covers campaigning, lobbyist registration, financial conflict of interest, and financial reporting obligations, for public officials. Conflicts of interest under the Political Reform Act are kind of a major area for all of us. And essentially the rule is this: a public official, as defined, may not take part in any governmental decision in which the official has a disqualifying economic interest. When it is reasonably foreseeable that the subject decision will have a material financial effect on such economic interest, a conflict exists under the Political Reform Act, and the public official with that conflict must recuse themselves from decision-making and, frankly, any involvement in the processing of that particular item of city business. Who is a public official? Public officials generally include every legislative body member, officer, employees at decision-making levels, and certain consultants of a state or local agency. It includes boards and commission members, but only when they've got final decision-making authority. In other words, planning commissions would be covered by this, but not necessarily just a recommending commission, say Parks and Rec. Consultants are covered when they are acting in a decision-making capacity and may have an economic interest in the subject of their advice. In other words, if they're paid to perform certain duties they say should be done as a result of their advice. There's the Government Code section which talks about this. There's a lot more to it than I just described, but again, they were trying to keep this at the primer level just for familiarity purposes. Okay, that's what a public official is. What's an economic interest? Economic interests include interest in business entities with over a certain threshold, real property interests over $2,000 of interest, or within 100 feet of a subject of decision, very important aspect of our compliance officer duties. Sources of income, sources of gifts over a certain level, and other personal financial effects. There's some exceptions to this. An interesting one that the public's never happy with: campaign contributions to city council members are not considered economic interests for purposes of decision-making. However, in an interesting twist to this, if there is a person running for office who is on a board or commission, campaign contributions to sitting board or commission members in excess of $250 are economic interests and are grounds for recusal. Interesting and important nuance that we should keep in mind, because of course, frequently people who are on boards and commissions do choose to run for office and might receive campaign contributions while they're acting in that capacity. Determining conflicts. The 4-way test used to be a 10-way test, then it was a 3-part test, and now it's a 4-part test, but I've outlined it here. This is what the FPPC has outlined as the approach to determining whether or not a conflict exists. First step is it reasonably be foreseeable that the decision will have a financial effect on any of the public officials' financial interests. If no, there's no conflict. If yes, you've got to go to step 2. Will the reasonably foreseeable financial effect be material? If no, there's no conflict. If yes, proceed to step 3. There's a lot of information about materiality standards in the regulations. The third step is, can the public official demonstrate that the material financial effect on the public official's financial interest is indistinguishable from the effect on the public generally? This is the public generally exception. It used to be a little easier to apply and understand and analyze and use an exemption. It's a lot harder now. So this is definitely an area, if you're involved, want to seek input from the city attorney. If yes, There's no conflict. If no, you go to the last step. Is the public official making, participating in, or in any way attempting to use his or her official position to influence the government decision? All of that's is the process for analyzing whether or not someone needs to recuse themselves. I'll briefly touch on the other kind of notorious bugaboo in all of this. It's Government Code Section 90. It deals with the making of contracts and prohibits, in effect, self-dealing. The basic rule is an officer or employee cannot participate in making a contract if they've got a financial interest in that contract. If that's the case, recusal isn't sufficient. The contract is void. The city can't enter into a kind of contract like that. And if someone did participate in that decision, that could be a criminal offense. There are some analyses here that allow remote interests in particular contracts to exempt them from this provision. They would just need to recuse themselves. Boy, this is a complicated area, applied in very interesting ways. If you're a person thinking about that from your own standpoint, ask yourself, hey, am I going to personally gain or benefit from this contract? If so, bring that to someone's attention in the attorney's office. But no matter what, it's a tricky area. You should definitely seek advice in advance or bring things to the attention of the city attorney if this issue comes up, because of how dire the consequences could be. So in thinking about how to comply with the Political Reform Act and these conflict of interest rules, I've talked about it in a couple different ways here. First, if you're a public official, really it's incumbent upon every public official to know his or her economic interests, to ask themselves, does the decision impact in any way an economic interest? If it does, you recuse yourself. But also remember, making a decision is more than just voting. It includes influencing that decision or being involved in something. So you need to recuse yourself from the get-go. If you ever have a doubt about that, seek assistance or consider recusal, even if you're not certain. And of course, keep up with your required ethics training. We'll talk about that a little bit later. So you're aware of issues and parameters and how to approach these things. Why this matters, why so much about conflict of interest and awareness and so many rules. It's really important for a variety of reasons. And I've touched on some of them already. If anybody violates these rules, there's very serious civil and criminal penalties that might be imposed on the official who's committed the violation. It could include forfeiture of office in extreme cases. And from the city standpoint, folks with conflicts of interest participating in those matters could result in invalidation of those approvals or the contract, with potential financial consequences arising from that. But maybe worst of all, and you all know this, we all know this in our roles and capacity, PRA violations will most certainly undermine the public's trust in its local government. And that's key for us to be able to operate effectively and provide services. And so this is important stuff for us nerdy rules followers. The next segment here, I want to talk a little bit about city attorney and city clerk roles as compliance officers in all of this. We'll talk about Form 700 administration, assistance with identifying potential conflicts, directing people to available resources, administering recusals, and administering AB 1234 training compliance. So a few things to talk about here. First of all, Form 700 financial disclosures. City clerks are the keepers of this and all that is good about it. And you know these rules, again, probably better than me, but for a quick primer, public officials, elected, appointed officials, manager level employees, as you know, are required to disclose specified financial information using the Form 700. The Form 700 must be completed and filed with the city clerk when assuming office, annually and upon leaving office. And all Form 700s must be publicly available, including on the city's website. Some practice tips Depending upon the public official's designation, some or all of the identified categories of economic interests must be reported. In the city clerk capacity, make sure your agency has the local conflict of interest code enumerating the covered parties. Make sure it's updated regularly. There is a kind of a incorporation by reference for a lot of this in the FPPC code of regs that I've identified here that you can use if you don't want to go wholesale yourself, and that's useful. Remember, of course, these rules can be complex. Consult the form instructions, as you know, which are actually pretty good in most cases, or the FPPC for guidance. They're actually pretty darn good with specific questions with pretty good turnaround times. But remember, in any of your administration of this, to stop short of providing legal advice. Helping people to fully complete the form in a timely and manner, and directing them to information and advice is definitely okay and part of your role, but stop short of advising filers on how they should complete the form. For example, advising regarding how dollar value calculations are made, or whether something's a gift or not, depending upon your relationship with the person. Those are things that the person needs to sort out for themselves. By all means, steer them to rules that you think are applicable and will be helpful to them. The next category of us where we work together as compliance officers is assistance with identifying real estate conflicts. And technically identifying all of them, but real estate ones are really the ones that I know a lot of us focus on because it's really tough to get at the other ones. I've outlined here, I don't think I'll go through the whole thing. Our own process here. But the bottom line is you really should work with the city attorney's office and your GIS department to develop a conflict of interest identification system, a process where you determine property holdings for members. The property information is provided to GIS, who maps that information and build into your agenda review process the checks and balances to make sure that more than one person even is cognizant of that, checking the maps and reflecting, any identified conflicts in the ultimate staff report. If in fact there is an applicable exception, the staff person and usually the city attorney's office work together to identify the exception and include that in the staff report as well. Ideally, in our case, you would separately notify the member in advance of your agenda, if possible, that there's a potential conflict and whether or not an exception applies, with a recommendation on whether or not they need to recuse themselves. So city clerk, again, working with other departments, the involved staff person, city attorney's office, definitely has an important role in this, in devising the system and helping with checks and balances, even if you're not determining conflicts yourself, in making sure that they're being determined, appropriate language is being used to describe them, and it's administered, properly and communicated properly to the party with the conflict. Here's a couple of sample forms that we use here in Chula Vista. I think we're going to end up trying to get those downloaded as attachments to these materials. It really is, as I'm looking at it here, intended to be clear about what item there's a conflict on, and whether or not that as a result of that conflict, there's an exception that allows them to participate, or whether they need to recuse themselves. There also is really good disclaimers here. We've indicate that we're searching based on real estate property holdings, but that this isn't, our final opinion. It's based on information that we have. If they've got other issues or interests in an item, we encourage them to review the agenda and bring those to our attention. And then we direct them to a phone number, give them the opportunity to work with us to go to the Fair Political Practices Commission if there's any, if there's any questions about Oh, now I've done it here. I may have just got us into a different mode. I'll keep going with this mode. Hopefully that can still be visible to you. Made the mistake of touching the screen to make it bigger for myself, and I changed everything for all of you. Sorry about that. We'll keep going in this mode. But by all means, take a look at those sample forms. If you're interested in any more of that information from us, follow up and we'll provide it to you. I think the next slide here, oh boy, I've really done it. Trying to get back to the report. And I may need, I think I may have blown this enough that I may need Carrie to step in now and offer to cue we left off. Carrie, are you there?
Yes, I am.
That's one of the problems with iPads. They make you love touching them. But then once you do, all hell can break loose. If you wouldn't mind queuing that up, Carrie, whenever you can, and then I'll.
I am doing that right now. Just one moment.
Very good. And I'll try to race you to see if I can do it. But I don't think I'm going to be able to successfully do it. We're on slide 44.
Okay.
You can pull that off for me. Thank you. My apologies. I lost myself in the beauty of the technology. There you go. That's probably better still. Thank you. So we've talked a lot about directing public officials to available resources, very important part of what we do. Here's the link for the FPPC. And there's a lot of good information there about how to obtain assistance from them as well. And like I said, they're pretty good about it. It takes about 21 business days for them to respond. Sometimes it takes longer if they need additional information. They frequently take longer if you're asking them on a 1090 issue because of the challenges of that. But by all means, avail yourselves of the good FPPC resources. Next slide, please. Administering recusals. So we've identified a potential conflict. We've communicated that to the decision maker, and now the next step is to make sure that's properly administered at the meeting, because there's requirements for that as well. And so, as we talked about, if a conflict exists, the public official must recuse themselves. And one of the keys to this is they must recuse themselves before the item is heard. And this usually happens, if it's happening properly, immediately after the item is called. Proper recusals require the recusing party to identify the nature of the financial interest forming the conflict. You don't need to be too detailed about this, but for example, if the conflict is and this is usually what it is, right? A real estate ownership, interest within 500 feet of the subject of the decision, that is what should be said and put on the record. Once that's done, the party should leave the dais and take themselves out of the decision-making venue. We've of course all been doing this virtually, and you can't actually leave the dais, but our equivalent of that is turning off your screen, and so no one can see your facial expressions that might otherwise influence things. And of course, not participating in any chats or communications while the item's going on. On the consent items, there's technically no requirement for them to leave the dais if the item is on consent. We don't require that if the item's taken up with the other consent items. But whether or not it's appropriate for them, that a person who's has a conflict to make a motion or second, the larger group. Different attorneys have different views about that and different views about whether or not you should even leave the room and have items pulled from the consent where there's a conflict. So by all means, check with your city attorney on the preferred approach to make sure you're helping administer something that your lawyer is comfortable with. Items, as you know, can be broken up into parts before the meeting to maximize the participation of decision makers. It's harder to do, but possible at the meeting if the conflict is identified, early enough. But ideally, of course, these things are identified and sorted through up front, so things can be broken out formally. The best practice really in all of this is the city attorney reviewing recusals with the providing officer and each recusing party before the meeting. The city clerk can help by stopping proceedings for recusal if it's not noticed by others. By all means, as things are going, stuff can get overlooked. So if you're aware that a conflict's been identified on an agenda, please interrupt and remind people that it needs to be dealt with. And if there's any circumstance where, because of the number of conflicts involved, there's not a sufficient number of voting members to approve an item, there is an exception where it's the legally required exception, but whether or not those circumstances apply or other circumstances under 1090 really isn't something that the clerk should be administering or deciding. It should only be done on the advice of the city attorney. Frequently, city clerks help with the managing the random process for selecting who gets to participate in order to reach a quorum and a sufficient number to participate, but very much of something that should be coordinated, ideally in advance with your city attorney as part of administering a recusal or a non-recusal in that case. Next slide. The last thing I'm going to talk about in this arena is administering AB 1234 compliance. As you all know, ethics training is now mandatory for public officials under AB 1234. At least 2 hours of training has to occur within the first year of service, and then every 2 years thereafter. You've got to maintain the certificates, and even those are public records available for people to review. Boy, a wide range of topics are covered and required in all of this, and there is training available online or through the FPPC. But I've got to say, no offense to the creators of that, because there's some good stuff in there. It really isn't that great. It's not that practical. It's really more of a scholarly exercise. And I would highly recommend that any of you consider working with your city attorney to create your own AB 1234 compliant program. We've done that here. We've been doing it now for, boy, Carrie, like nine years, almost shortly after I got here, maybe even more, maybe 10 years of this. We're getting better at it every time or not. Maybe we're getting ridiculous, I don't know. But in the programs, or in the program materials, I've actually got our most recent PowerPoint that constitutes our city-sponsored AB 1234 compliant training. It's much more comprehensive and practice tip oriented than the one that's online. We had this last October 1st when we did it, over 100 attendees who did our training instead of the online training. We've had as many as 70, 75 at the ones that are live. Carrie was even my team presenter this last go around on the Brown Act and Public Records Act area, and she made that section better for sure. We try to make it fun. We've got interactive quizzes, hypotheticals, trivia contests, prizes, intermissions. We have with pizza in the middle of it, because it's a slog, right? Like maybe this presentation is becoming, but it's a lot to get through. And so anything you can do to spice it up and make it interesting is really good, and gets people engaged in it. So we've had fun with it. If anyone's interested in how to go about doing that, don't hesitate to reach out to me or look at the sample that we're providing, because I think it really is a much better way to impress upon people the importance of these rules, how they affect how they conduct themselves as public officials, and how to be helpful in spotting, issues and making sure we're all kind of mutually supporting compliance officers for all of these different rules that apply to us.
Glenn, we have two questions in the chat. One question is, all public officials in quotes, does this include commissioners that do not receive compensation or stipend?
Yeah, I think you have to be, I think the way we've interpreted that, Carrie, here is if you have the potential to receive reimbursement for expenses, we've treated them as being public officials so long as they are on boards that make recommendations. If they're not paid and are on a body that's just a recommending body, I would say they're not public officials for purposes of this. But that doesn't mean, again, you can't be broader, right? With how you apply this. And I think the place that a lot of places err on the side of, either if there's uncertainty or it's kind of confusing to keep track, right, of the different categories of people, is you apply it to a larger scope. And as long as people are willing to do it, it's good to capture the largest group possible.
Thank you. One other question is if you have any recommendations on how to address non-compliant. This is asking about non-compliant filers, so it may be in with respect to Form 700 filers.
And again, is the non-compliance meaning failure to timely file? Is that the issue?
I'll see, Kimberly, if you can follow up on your question. I'll jump in when we have. Oh, this is for AB 1234, non-compliance for AB 1234.
Oh yeah, boy, that's
training.
a great and that's a great question. Yeah, because we do have that issue. One of the things that we have done with employees, it's relatively easy, right? Because it's a term of your employment. And if you don't come into compliance at a certain point, it can result in a disciplinary action, being taken with respect to you. With respect to boards and commissioners, we try a ratcheted approach, right, Carrie? We send letters out, and we send reminder letters out. We continue to offer the resources. At a certain point, the mayor, we play the mayor card, and the mayor gets involved and says, hey, we've been trying to get you, information and in compliance. Please come into compliance right away, or your position may be subject to forfeiture. We would take that up from time to time, with the mayor, and for a while we had a subcommittee, right, Carrie, to evaluate those types of things where people weren't either complying with their showing up enough to boards and commissions, themselves to meet their attendance standards, or other non-compliance. But usually, Carrie, and you tell me if I'm wrong, even if people have been defiant, a letter from the mayor saying they might forfeit their position either inspires a resignation because the person wasn't that engaged anyway, or compliance. And that's what we've been doing. Carrie, what do you think?
Yes, I'd say that's accurate. And we also relatively recently started not reappointing people if they're not in compliance, or we'll give them the reappointed contingent on them becoming in compliance within 30 days or 60 days or whatever it is. So I think that's helped as well.
Yeah, very good. Very good. Okay, I'm going to keep, maybe I'll stay around for questions at the end. I've got to keep jamming here if I have any hope of getting through all this. Next slide, please. Brown Act, my favorite Norman Rockwell man coming to talk to his legislative body picture. Next slide. Please, you're all familiar with the Brown Act. This gives some background on it. Nice picture of Ralph M. Brown. Next slide. Core principles of the Brown Act are worth touching on, at least briefly. We all know how important this is at the center of open government and transparency. It's really important that local agencies deliberate and take actions only at public meetings. It's important that the public be notified in advance of all those meetings and of the matters that are going to be considered at those meetings to see if it's something they're interested in participating in. The public must be given access to the information provided for those meetings and an opportunity to provide input to the decision makers. And any exceptions to this basic rule of public meetings and public participation are very, very limited. Next slide. Who is subject to the act? As we all know, again, it applies to all legislative bodies and their members. This includes city councils and county boards, board commissions and committees, subcommittees of a legislative body, with limited exceptions for qualifying ad hoc subcommittees, and I'll talk about that in a minute. Regional boards and even bids and P-bids under the Streets and Highways Code have Brown Act obligations or open meeting obligations. It does not, interestingly, govern conduct of city staff because we're not legislative decision makers, but as we'll see, staff can play an important role in making sure that their boards and commissions and other legislative bodies comply. Next slide. There are special rules for certain subcommittees. City clerks might be called upon to observe or comment on this, depending upon who's staffing what board or commission and whether or not there's a lawyer there. As we discussed, the Brown Act generally applies to all boards, commissions, committees, and other bodies, regardless of whether or not they're decision-making, even recommending bodies are governed by this, a distinction between how the Political Reform Act applies to those bodies and its members. It applies whether the body is permanent or temporary, advisory or decision-making, as I said. And there is a limited exception for a true ad hoc subcommittee. And these are created frequently, in fact, in our city. But there are very specific rules that apply in order for you to be an ad hoc subcommittee that can meet privately without Brown Act noticing and public attendance. It can only be comprised of less than a quorum of the members of the appointing body. It cannot have continuing jurisdiction over a particular subject matter. It needs to be focused on a particular project in effect of short term. It cannot have members of other legislative bodies or other third parties. In other words, it can only be those members of less than a quorum of that legislative body. They can certainly meet with other parties if they want to. They can meet with whomever they want. They just can't have others members and making decisions, for them. And it needs to be for limited duration. Ideally, the safe harbor is 6 months or less. We've had them last up to a year as long as all these other criteria were met and their focus was very specific, but 6 months is considered the safe harbor. If a staff, department head or otherwise creates a citizens or business committee, those are also exempt. Only committees that are created by the legislative body itself are potentially governed to the Brown Act. There's a lot of gray areas here. Please consult your city attorney with any questions. Next slide. Definition of a meeting. I think we're all familiar with the core definition here, with the reminder that decisions don't need to be made there. A group getting together, same time and place to discuss or deliberate something within the jurisdiction of the public body doesn't need to come to a decision for that to constitute a meeting governed by the Brown Act. And it can include formal, informal gatherings with or without public attendance or city. Next slide. What else is a meeting? This gets a little interesting here. As all of you know, probably, and very familiar with, written communications, including emails between a majority of the members of a legislative body, can be a meeting for purposes of the Brown Act and potential violations. Intermediary communications between folks, where someone's acting on behalf of somebody else and communicating to ultimately a majority. Those frequently occur in serial communications, which are described here in some examples. Next slide, please. Carrie put together this very good slide with graphic depictions for her last presentation about serial communications in either a daisy chain, one to the other, or a hub and spoke, format. Again, unusual form of meeting, but a meeting nonetheless, governed by the Brown Act. Next slide. Exemptions is where we often come in because people ask us whether a certain gathering is governed by the Brown Act, and this goes over those here. It's not a meeting for Brown Act purposes if a majority of members attend conferences that are open to the public, open and publicized meetings of a local group, open notice meetings of another legislative body, social or ceremonial events, or open notice meetings of a standing committee, as long as you don't participate. Notice here that there are all sorts of possibilities for both the perception of an unlawful meeting and unlawful interactions at such of these gatherings. These gatherings aren't inherently public meetings, but we need to be very cautious. Only if we have a real concrete understanding about all the particulars of a meeting. Are they charging? Is it ADA, compliant? Were invitations sent out to only certain people or others? How many of you really are going to be there? Is there an opportunity for discussions or interactions amongst you on a matter of public interest to the city? All those things are factors where we may want to advise, hey, you shouldn't go to that, or we'll help you communicate with one another for scheduling purposes, who should go this time or the other. So it's really important when these questions are asked of us, and they're frequently asked either of the city clerk or the city attorney, that we gather all the necessary information and sort through all the particular circumstances surrounding that before we advise. Next slide, Carrie, thank you. Some more meeting exceptions. Communications that are sent to all council members aren't meetings by themselves, but of course create a risk of that if they start replying all and deliberating in a serial way or otherwise. And so that's usually part of our training of our public officials to be careful and not to do that. Communications for purposes of calling a meeting or setting an agenda are also not meetings. There's a specific exemption in the Brown Act for scheduling communications amongst council people or legislative body folks. Polling, obviously, it helps to have everybody know who's available for what, as long as they don't dive into the substance of things. That's exempt. And then, of course, individual contacts or conversations between less than the majority of members and or with members of the public aren't either. But of course, there's always a risk or an appearance of impropriety if too many of them are gathered in one place. Next slide. Meeting notice requirements. You guys know this stuff. 72 hours for regular, 24 hours for a special meeting. Notices have to indicate the location and the time of the meeting, the description of the items to be discussed. Those notices need to be posted and mailed to those requesting. And now, of course, they also need to be posted on the internet. And starting January 1st, 2019, the website posting must also be prominent and searchable. So not just posted, but must have those features as well. Next. Meeting location requirements. I'm not going to go into this too much. There's a lot of requirements here that talk about meetings within the boundaries of the city, except in these particular instances where there is exceptions. In all cases, the location must be ADA accessible, and remote attendance by teleconference is possible. And we'll talk about that in a minute, under certain rules and conditions. A really important practice tip in this is the Brown Act sets up certain rules for where meetings can be held. But frequently local rules have their own standards for that. Our charter has provisions on that that are not exactly consistent with what the Brown Act calls for. So please be aware of your charter and your municipal code in this area for special local requirements. Next slide. Okay, what we can talk about at meetings and what we can't, as you all know well. Only items listed and clearly described on the timely posted agenda can be discussed or acted upon. And it's really important, as a result, that the agenda includes a clear description of what's being considered. It doesn't need to be long. In fact, the Brown Act explicitly says it doesn't need to exceed 20 words. But if 20 words isn't enough to describe it, you need to use more. It's also important to make sure that there is a reference in the item as to what is being sought with respect to that item. Is it approval of a program? Is it simply direction to staff? Frequently, agenda titles are not adequate, and it's helpful for city attorney and clerk both in reviewing agendas to spot those issues and help bring agenda titles up to speed. If there's ever a question at a meeting about the adequacy of the description of the item or whether it's on the agenda and you can't get hold of the attorney or the attorney themselves isn't sure, better not to act. Hold off, put it up on the next agenda. Next slide. Here's a couple of examples of agenda headings and titles. Discuss Arts Master Plan. Doesn't really tell you what's going to happen there, particularly if an action is contemplated. On the right, you'll see the better one that talks about exactly what's going to be going on in clear layman's language, whenever possible. Same thing with the next item, fiscal year 19 plan reallocations. No one can tell what's going to happen there or whether an action's contemplated. Here's what's being contemplated on the right with an adequate description. Next slide. Another couple of examples of what's good and not so good. In the first instance, proposed amendments to City Parks Master Plan to add recreation facilities and corresponding amendments to the City Master Fee Schedule to increase public facilities development impact fees. It's a resolution approving that. Clear what's going to happen. On the next one, Parks and Rec fee increases. No one can possibly know what's going on there. And that, I would argue, is inadequate. Next slide. What you cannot talk about, obviously things inadequately described that aren't on the agenda is one of those. And if it's not on the agenda, really the only appropriate action is to refer the item to staff for consideration on a future agenda. If something comes up in public comments or otherwise, a brief response from staff or a question or a statement is okay, but really things that aren't on the agenda ought not to be discussed in detail or deliberated on. I know our city council people sometimes tax us this way, either on an item or in their comments, and you want them to be able to express themselves about things, and they can, as long as it doesn't trigger deliberations or interactions with the other council people. There's limited exceptions to when items can be added to the agenda. Obviously, in the event of emergency, with a vote declaring that emergency, or an urgency item where a supermajority vote allows an item to be added if the matter of urgency comes to everyone's attention after the normal posting time. So be aware of those. They are things that can be implemented on the dais, best done with your city attorney's advice and support. Next item, dealing with last-second agenda items, proposed ads. This never happens, right? Everybody, no one ever wants a last-minute agenda ad. We, of course, deal with that as best we can with a day before agenda process, before the actual posting needs to go out. Poor Carrie and her team are traumatized by my office and every other office, and changes are made right up to the last minute, after the last minute, amendments to the agenda, and we know it's very complicated, and somehow Carrie figures it all out, and her team keeps the sunniest, nicest professional disposition with everybody. I only can imagine what you talk about behind our backs, but you're all very nice about it. But sometimes there's things come up, right? And our council people want to add something to the agenda, you've got to adjust. So last-second ads are possible, obviously, as long as the advance notice requirements are met. You could even call a special meeting on an item if it's really, really unimportant and comes up later, you know, with the 24-hour notice, if you blow your 72-hour notice. You want to check your local rules as to who has the authority to add items to an agenda. In our case, interestingly, the city clerk, the city attorney, and the city manager have the independent authority to add items, but the mayor doesn't, other than items that are, you know, under her authority for appointments. And the city council needs to vote by a majority in order to add something. No individual council person does. This was coming up a lot, and we had to sort through all that. And we, when city council people were very annoyed, you know, that they had to ask permission to add something of different individuals. And so we developed this process, and we'll put that in the packet because it's a really kind of good way to orchestrate a way to get an item on the agenda without violating the Brown Act, if a city council person wants to propose that out of order. Next slide. Obviously, public needs to have access to meetings and materials in order to comply with the Brown Act. I've got a list of all the different things here that they need to be able to do. You guys are familiar with these. I'm not going to go over them, but the slide's there if you want a good summary. Next item. Public comment, another thing that that city clerks and city attorneys help administer. As you know, at regular meetings, public comment must be allowed, but local rules can be made about how long public comment needs to occur. Typically, I think most jurisdictions have a 3 to 5 minute time frame on comments for items that are on the agenda. You can make different rules. Boy, if you start going before 3, you may want to, or 2 particularly, talk with your city attorney about you know, due process issues that might create, particularly for items that are on the agenda. You also want to make sure that your presiding officer is administering this very, very, you know, fairly and equally. So that's a good aspect of training for boards and commission, you know, heads and presiding officers of every type. You can't give one person one amount of time and another person another, either for expressed reasons or even inadvertent reasons. You really need to be conscious of fairness here. On non-agenda items, comments must also be allowed, but no action or discussion can occur. Again, if it's not on the agenda, questions can be answered if someone poses a question through the presiding officer. Brief responses can be made. Council can't deliberate on it, but certainly referrals can be made on those items. So that's the way to deal with that. Next item.
Glenn, we have a question about limiting written public comment. The question is, can we limit the amount of written public comment, meaning pages of email material? Some agencies get thousands of pages as attachments to emails.
Yeah, I don't know the answer to that. I don't know that there's a case or a statute on that, but to be honest, my answer would be no. My instinct is no, that you can't limit how much information people want to give you. Obviously, you know, figuring out how to distribute that is the issue, right? If someone gives you 1,000 pages, do you have to digitally enter it, you know, and then make it available for everybody in that way? That's a good question. I bet you could probably, in that instance, if you don't have the capacity to do that and distribute it, indicate that it's available for review, you know, at the city clerk's office and on the dais when the item comes up. But I don't think you can actually limit people's ability to provide information, you know, to you. And you really need to come up with some way to make it available.
Thanks, Glenn. One other question is, do you allow comments on agenda items when that item is heard or at other times as well?
That's usually up to the presiding officer. I mean, I think the best practice is if an item's been heard, it's been heard, particularly if an action's been taken. A council person at the same meeting can make a motion for reconsideration or to reopen that item. And if the majority of the council wants to do that, that can happen. But I usually leave that to the discretion of the presiding officer. It's different if there's a public hearing, right? And there's been a very ordered, structured due process hearing and someone comes in late, you know, and wants to provide their comment. in that instance, I think you're probably better off not allowing that comment since it kind of came out of the flow of how information was being provided and the decision was being made. So those are my best thoughts on that. So special meetings, you still need to allow comment, of course, at special meetings, but you don't need to allow comment on non-agenda items. In other words, just public comment in general isn't necessary at special meetings. A lot of agencies do it anyway, and it's certainly okay for you to do it. But if it's only particular subjects at a special meeting, you don't have to have general public comment. As you all know and are helping implement, there are special rules for non-English speakers now to allow them twice the amount of allotted time for translation unless simultaneous translation equipment is available. So be aware of that and help make sure your office is compliant, your agency is compliant. Closed session. I'm not going to spend too much time on this as we run out of time. Obviously, we all know this is the exception and not the rule. These are all the exceptions that are listed there. The next slide, please. There is some practice tips and roles for city clerks in this. You do want to make sure that the agendas are using the safe harbor provisions in the Brown Act for the particular type of closed session that's listed. If you're going to vary from that in terms of what it's being offered on there, make sure that's being done with modifications by the city attorney. Better you're not creating those in final form. In general, if you're providing support for boards and commissions, there's almost never any legal basis for them to go into closed session. So if you see that happening, you may want to alert people to that and suggest they not do that unless they've had the advice of their city attorney, if the city attorney isn't actually there. You do want to remember, as a matter of course, to allow for public comments. If someone has the closed session items are agendized and someone's there and puts a speaker slip in and says they want to comment, they absolutely have the right to comment on that. We do get that from time to time with respect to labor negotiations when a labor group wants to come and speak their piece before the council goes into closed session to deliberate there. You definitely want to coordinate with your city attorney on reportable actions that either are at the same meeting or upon inquiry if the agreement is not yet finalized or reached, and with making sure that there's the required record keeping of closed session actions and minutes is being maintained. So those are things relevant, I thought, to the city clerk and the city attorney coordinating. Next slide, teleconferencing. Boy, these rules kind of seem outdated now, don't they, with COVID kind of having blown the doors open to it. We may come back to these rules again, or maybe not, with how things are, but it was allowed before the pandemic, modified all the rules. These are the special rules for it. It's interesting that there currently is no legal requirement, even if you've got council people participating via teleconferencing, that the public be allowed to participate in that way, even though obviously a lot of us have done this. And I know the ACLU has raised issues about interpreting the Brown Act and the governor's executive order to require more. But I don't agree with that. Obviously, we should all try to, as open government kind of professionals and guardians, to support and encourage making available all different forms of input from the public. But oftentimes there's just, as you all know, resource limitations or technology limitations that kind of make that hard to unveil in a fair way. So we'll see if these teleconferencing rules end up continuing to be relevant after COVID, or whether they're loosened up. Next slide. I talked about this already a little bit. Obviously, a lot of the rules have been suspended as to what's required for council people to be in chambers and for the kind of input that's necessary. And I already talked about this. I think enough to go to the next slide, Carrie. Here's some just practice tips, I think, for all of us as we move towards reopening. City Chula Vista just had its first swing of the bat, if you will, at having live testimony. at our meeting. We actually had phone-in testimony for the first time at a public forum a couple weeks before, but just this last Tuesday, we experimented with this, and I thought pretty successfully, Carrie, don't you? In terms of what we were able to manage with people being in an outdoor lobby, queuing up, a lot of them being able to be seated and spaced apart safely in chambers. But depending upon how you want to do this, definitely keep in contact with your local county health officials. You're not all in the same tier, right? And regardless of what tier you might be in, different views by your county health officials of the extent to which live council meetings might be allowed and what rules apply may exist. So you definitely want to be coordinated with them. Also, of course, keep in contact with your city attorney's office. And interestingly, ADA compliance may require additional accommodations beyond the standard ones. If in fact someone has a vulnerability to getting COVID or serious implications from COVID, you may need to provide them special spaced areas or otherwise. We at our last meeting were able to increase air circulation, and we started that even before the meeting occurred in the areas where public were located. We did temperature checks of people before they were allowed admittance. We set up chairs spread apart in our outside lobby. We did require masking, 6 feet separations. People were ushered in and out of different doors when possible. We did do wipe downs of the dais in between speakers when people touched things. We thought it went pretty well. I don't know if we're switching over to that entirely, but it was nice to be able to have a successful dry run of it. Next slide. An emerging area is social media and the Brown Act. And we used to talk about this as an emergency area with no guidance. Even though we knew the Brown Act applied, it was unclear exactly how it did when people used social media. Well, now we kind of know. Next slide, please. We don't have cases yet that I'm aware of, but we do have AB 992, approved by Governor Newsom on September 18th, 2020. It's really the first amendment to the Brown Act to address this. It does allow public officials, of course, as they need to communicate via social media to answer questions and provide information, and particularly if people are soliciting that information. But it includes limitations, appropriate ones, to prevent public officials from, in effect, having meetings on social media, with each other, and even posting comments or using digital icons like emojis to express your reaction to another legislative body member's post may be viewed as a communication for Brown Act purposes. And so it's helpful to have guidance in this regard, finally, from the legislature. Next slide. The parameters of this are pretty broad. It applies to pretty much all social media platforms. And if public officials are using them, people need to have access to them free of charge. They cannot be blocked. A lot of these rules are important and meaningful, but not things that city clerks are particularly called upon to be compliance officials for, so I will spare you any further discussions of that. Next area that I hope to get through is important is meeting management. I'm going to touch on these pretty quick, although I think they're important, useful tips in terms of city clerks and city attorneys working together to manage meetings. You definitely want to confirm that consent items are okay to be on consent. This isn't a Brown Act requirement necessarily, but it's just a legal requirement and a good heads up for each other. Some actions require announcements or can't be approved on consent agendas for legal reasons. And so, for example, certain actions in connection with assessment districts can't go on consent. So be aware of that and have that be a good check and balance for you in preparing agendas. You also want to confirm and indicate any supermajority voting requirements on items. For us, any amendment to our budget requires a 4/5 vote. And as you all know, there's other things both under state law requirements, condemnation, for example, or other legal requirements where supermajority votes might be required, both on state and under your own local rules. With public hearing items, you definitely want to confirm that your public hearing notices were made in compliance with applicable law. There's frequently different time periods depending upon what's being approved for what the notice requirement is. 10-day is typical, but sometimes it's 14 or even other types of requirements. So make sure that's been done and you're getting the proper advice on that. For land use approvals, licenses and appeals and other quasi-judicial approvals at public hearings, be aware and help administer local rules affording due process. Who gets to speak first, who speaks second, how much rebuttal time there is, the ability to provide evidence and information, all of those things that kind of we're collectively responsible for administering and making sure the rules are followed, and helping our presiding officer oversee that in kind of a fair and appropriate way. With complicated items, either the kinds I just described or in a lot of kind of assessment district, protest vote or other vote count, situations, it is a good idea to help in the creation of a script for your presiding officer and others as to exactly what happens in what sequence, particularly in complicated matters involving multiple, decisions. It's really, really helpful. And I think when I finalize all of our different materials, I'll make sure a couple of scripts that we had put together are provided to you as examples. That really your presiding officer is trying to juggle a lot. Some of this stuff's really complicated. The more you can help him or her in performing their duties, the happier they'll be, and the less likely you're going to have legal challenges on you not doing something right. Because particularly in areas like this, there are high stakes decisions that are subject to legal challenge. So you want to get it right. So scripts are a very good tool. Next slide. For meeting management, another thing you can do is help clarify unclear agenda items. We talked about that a little bit in the earlier section. If draft agendas are not clear on what type of action is required, you can suggest clarifying modifications. For special meeting agendas, confirm that the contemplated action can lawfully be taken. There are rules about what can happen and what can't at special meetings, both under state law and under a lot of local laws. For example, that you can't approve issuance of debt at a special meeting. It needs to occur at a regular meeting. You also want to familiarize yourself with your jurisdiction's parliamentary procedures and be prepared to assist your presiding officer. You may or may not have a formal role, in this, depending upon your local rules, but knowing the rules and being helpful and spotting issues is good. My rule on this is a pretty gentle touch. We have a pretty detailed code section, don't you think, Carrie, about how all of this needs to work and the priority of things. You know what? 99 times out of 100, you don't need any of that. If they are figuring it out themselves and it's just a local rule, leave them be. It doesn't need to work any particular way. But if someone calls the question, or says, wait a minute, it can't work this way because they've got an issue about how it's going, it's really helpful to be familiar with those rules and help your city attorney and your presiding officer sort through that. Consult with and defer to your city attorney. Ultimately, we're responsible for that. And I would like to put a plug in here if you don't have your own detailed rules for Rosenberg's Rules of Order. Robert's Rules of Order is kind of the more famous one, but it really isn't drafted for legislative bodies, and Rosenberg's is much better and more tailored, for our purposes. Next slide. I'm going to have to really hustle through the these last few areas. Public Records Act, and I'm going to skip, I think, next slide even, Carrie, these core principles. We all know how important it is as part of open and transparent government, that public documents be available to the public upon request, and the idea that a public record is broadly defined. Next slide. Here's a little bit of a treatise on all of that. It's basically everything unless an exception applies. No matter what its physical form, is. Next. So there's a lot of nuances here. I'm sorry I'm going so fast, but I do want to get to kind of some of the practice tips because I know a lot of you know this. What is not a public record? There are exceptions in limited circumstances, and they're narrowly construed. There's both specific exceptions that are listed in the government code, and then there is a balancing test. The specific exceptions, most of them are in 6254. Other code sections on particular records have their own exceptions, so be aware it's not just all listed here. But the balancing test is the tricky one, a balancing of interest. If something isn't explicitly exempt, you've got to balance the interests of public benefit of disclosure versus the need or rights to privacy. And this is definitely an area where you want to be locked in with your city attorney on. You don't have to produce or provide records that don't exist or where the request is unduly burdensome. Again, consult with your city attorney on what the latest parameters are for that. Obviously, you can redact private confidential information, and that's another important exercise in coordination with your city attorney. And some deliberative process records may be exempt. Next slide is kind of the another important principle regarding responsiveness, clearly required, and some sort of response is required within 10 days of the request. Additional time allowed under limited circumstances, and all these other additional duties I know that you're all familiar with. Particularly helping the requester, kind of a relatively new one in the last 10 years, kind of a duty to help the requester formulate an effective request. If you don't want to just say, no, that doesn't make any sense to me, you're supposed to reach out to them and help them formulate their. Next, here's an important practice tip I wanted to get to in the last couple minutes that I have. I think it's really important to develop a coordinated system between the city attorney and the city, the clerk's office in this regard. This is a complex enterprise. A lot of rules apply to it. Easy to miss things and not turn over things you should, or in some respects worse, turn over things you shouldn't. Being coordinated and there's very short timelines, right? And I don't know about the rest of you, but we're seeing an uptick, in the amount of requests people are making, particularly of our police department. And so being squared away on this is really important. And any policy you make should be clear about the roles and expectations that you've got from staff providing the information. Ideally, you're training staff. And again, I mean, even throughout the department, so they are knowledgeable about the rules and the time and the importance of the timeliness of their response. Really important that to maintain effective communication between the internal stakeholders. Really important to catalog records that you're providing to the requester, to establish institutional knowledge and awareness of the city records that are available, and maintain consistent and clear communications with your requester. We've either attached already or will attach a summary of our Public Records Act response system that was prepared by Mike Shirey. It includes form letters. Obviously, don't use any of that without the approval of your city attorney and legal advisor. But I think he did a really nice job of outlining both the process that the city clerk goes through, that the city attorney goes through, and how we put our heads together to respond to records. The last set of tips here I have in this area are in the Public Records Act arena. Put as many public records online as possible. Create city attorney approved forms for requests and responses. Use the interactive process actively to clarify and narrow requests. Discourage use of private devices by city officials and employees to conduct city business. We all know in the wake of San Jose, the challenges that creates for us. Develop a policy for soliciting and obtaining public records information from people's private devices. Another important thing to make sure you're having fair and appropriate interactions with folks. And then again, formalize and actively implement your document retention and destruction system, make sure the city attorney reviews that so that the appropriate records are available for people or not because they've been destroyed. I think it's really important for city clerks to stay connected with their counterparts in the police departments and be actively involved in the records disclosure system, particularly with the volume now that we have like that. That's something that we need to work on and enhance over here. I've got a couple more. Next slide, please. Slides on candidates and elections, but I think I'm out of time, and so I'm going to skip that. Those last few slides. Hopefully those will be some helpful tips to you as well. Really focusing more on making sure you're providing information and not advising people, and introducing the appropriate caveats as I suggested early in my presentation on making sure you're not crossing the line into providing advice. So please take a look at these materials, and if you've got any questions about it, contact Carrie or contact me. I'd be happy to talk to you and explain any issues. I know we're kind of at the end here, but I'm willing to stay on and answer any additional questions people might have, if in fact that's even allowed. Oops, I'm not hearing you, Carrie. You're muted for me.
Sorry, I think I was
There you
muted
go.
for everyone.
Yep.
I'm not sure if it's allowed, so we'll start, and if they kick us off, then we'll leave. I was holding a couple of questions for you because I know you were trying to get through the presentation. One of the questions was, how do I convince my new city attorney that we often place items as public hearings that don't necessarily require one, i.e. not all first readings of ordinance require public hearing? Our community does not understand that if something is not listed as a public hearing, that they still get to speak. The attorney insists that we not list public hearing if it's not necessary.
Yeah, that's an interesting question and conundrum. I get your city attorney's position. Public hearing connotes kind of some special legal elements, including formal advance, notice beyond simply posting of agendas, right? Publishing in the local newspaper of record. It also frequently attaches with it due process kind of considerations and concerns that don't necessarily attach to conventional agenda items. I might suggest working with your city attorney to come up with an amendment to your action item moniker to maybe make that more clear, that public input is welcome. Action items for public input, with public input, maybe, and so that it's not you're not calling it a public hearing because that connotes something special, but you're communicating through your action item heading that in fact public input is welcome. That'd be my suggestion in working with your city attorney on that.
Thank you. Another question, I know you said to check with the attorney, so maybe that's still your answer, but Sherry was asking, how do we define unduly burdensome with respect to CPRAs?
And I'm sorry, I'm not super keen on some of those definitions there. If I had my attorney here, Mike Shirey, I would ask him, and he'd probably have a better informed answer for you based in case law. But that's definitely something that I know is case by case, right? It'll depend upon the kind of record they're asking for, the time period, that it relates to, the volume of records, involved. All of those things may form a basis for something that's unduly burdensome, but I'm sorry, I don't have the precise parameters of that for you off the cuff.
My advice for you is, if you think that it's unduly burdensome, then ask the attorney to give you an opinion.
Beg the attorney to agree with you.
Yeah, and sometimes, as far as that goes, we've gone back to the requesters. Like Glenn was saying, one of the requirements is that is that we work with the requesters to make sure that they're getting the records that they're looking for. So sometimes when we go back to them and say, this is going to result in 10,000 emails, that would all have to be gone through, they're really looking for something specific. So a lot of times we can communicate with the requesters themselves to make those unduly burdensome requests easier for us to handle. And I think that's all the questions that we have here. If anyone has any last minute questions, or if I missed you, if you could put it in the chat, we'll be happy to respond.
Yeah, and please avail yourselves, again, when we get it up there, through the CCAC and this forum, of any of the materials that we've put together. And again, I can't emphasize two things enough. How much I value city clerks and what you guys do, and how much I value the importance of our professional relationship with each other. We really do have really the same interests in making sure things are done the right way, and our relationship that reinforces each other and our respective roles, I think performs a really crucial service to the city. The relationship with the public now more than ever is really important to maintain in order for us to be able to deal with all these issues and get things done and services out to the communities in the way they deserve. And I put city clerk and city attorney at the hub of that, even if maybe only city clerks and city attorneys do. So I definitely want to emphasize that. And one last thing, doing your own AB 1234 training is a really great way to reinforce the culture of openness and ethics, within your organization. So if anyone wants to inquire with me about how to go about doing that, I'd be delighted to talk to you. That's it for me.
Glenn, two more questions that popped in. One is, can you have a commission meeting be a training meeting for all commissioners?
Yes, you can. But what we've done before, again, to kind of model good behavior, right, Carrie, when we've had the council people at our training and we know they're all going to be there, we notice it as a meeting. So the answer is yes, and I would notice it as a meeting.
Yes, that's what we do for council. And also, I'm not sure if you were on our board and commission training right before this, but I had mentioned that we do training for boards and commissions, and we do kind of a roadshow and go around to all the commissioners. We also notice those as meetings, so the public can come and listen to that training as well. Yep,
very good demonstration of how we value those things and take them seriously enough to train them. And the public learns about it too in the process. So right there with you.
One more question is, have you had to address use of devices at the dais?
I have not. I know that almost everyone has their phone available. I've got my phone on the dais. I'm sometimes working, right? I'm texting people and responding to emails, in dull moments or moments where I'm not required. There's nothing unlawful about it. There is the potential for Brown Act violations, obviously, if council people are using their phones to communicate amongst themselves. There's also potential due process violations during a public hearing if people with an interest in a matter are communicating with the decision maker, and in effect they are receiving an ex parte communication outside the context of the public hearing that no one else has the the benefit an advantage of hearing. And so I would support, if that's been a real issue in your jurisdiction, a policy about that. Your council, your decision makers are probably going to bristle, at it. But if they're doing too much of that and creating an appearance of inappropriate kind of communications, then I think it's warranted.
Okay, thank you. Those are all the questions that we have.
Beautiful. Thanks again, everybody. And again, appreciate the opportunity to present to you and appreciate Carrie Bigelow more than I can say.
Thank you. Likewise.
Thanks. Bye, everybody.